all about our consultancy services regarding to MiFID 2. For those of you who are new to Knight IT, we're a Technology Alliances partner, and we work with your organisation to manage your IT infrastructure and provide cost-effective and accurate solutions. So Knight IT gives you more time to concentrate on your business, so you can do what you do best. Consultancy is a key area of our business, and our consultancy services span infrastructure strategy, implementation, and managed services. But one of the key changes we've seen in the marketplace that's prevalent now is MiFID 2. So having searched far and wide for the best consultants in the space, as they have extensive knowledge and experience in the MiFID space. So on today's webinar, we'll take you through the presentation and open up for questions.
Lovely, thanks for that, Matt. Before we crack on, I'd just like to say we really appreciate the opportunity from Knight IT. It's a real pleasure to be asked to partner with them on something like this. Hopefully, for the rest of the presentation, you'll get an understanding of the potential impact of MiFID, the timescales, why we think it's such an important piece of regulation for financial services to be aware of, and then a little bit about what consultancy services, be it Knight IT, can assist you with in becoming compliant, becoming ready for the implementation of MiFID. Diving into the slides, time is running out. Little bit of a challenging title, that is, because the timescales are still uncertain. I'll talk a little bit more about that in a moment. Just to introduce the speakers, my colleague Slavea will be jumping on in a little bit to talk to you about some of the detail of the regulation. Slavea has been a consultant for several years. She's got a very good understanding of the wealth management industry, in particular as she was previously an analyst at Compere, the company that does IT, does benchmarking for the wealth management sector. My name's Ian White. I'm a senior consultant. I've got a number of years, too many to think about really, experience in the wealth management industry, running all sorts of projects, but particularly change projects, and for change projects looking at the regulatory landscape and all of the various regulations that have come down over the years that impact wealth management, and making sure that those changes are done in a timely and effective way with the minimum of business disruption. A wealth of experience in the financial services sector. We are independent. Obviously, we're linking with Knight on this webinar, but we're an independent firm. We will provide you with project management, program management, change management expertise to make sure that you have the people deliver that change successfully. And there's a few of our clients in the wealth management space there for you to look at. So what are we going to be talking about today? It's going to last about 45 minutes. I think the webinar software should allow you to type in questions. If you want to do that, that's fine. And we'll open up the microphones for questions at the end of the session. So if you come up with anything through in the interim, then please type it in. If not, we'll talk about it at the end. So what are we going to cover? An overview of MiFID 2, what's included, a little bit about the timescales, a little bit about the uncertainty that's still out there for MiFID. We're going to look at what the impacts of those regulations are on your business. Then we're going to think about how you can structure a project to make sure that you can deliver a successful MiFID compliant organization, and a little bit about Knight at the end, how we can actually assist. And then obviously, as I said, we'll take questions at the end. Okay, so I'm going to hand over to my colleague Slavea now. She's going to talk a bit about the delays and a little bit about the detail of the regulations over the next few slides.
Thank you very much, Ian. Good morning, everyone. I'm going to start with some recent news regarding MiFID, and that's that MiFID may be delayed. I think there is a good reason, and our advice is to ignore these news for now, and there are a few good reasons for that. The first one is that MiFID is such a complex and comprehensive regulation that even if there is delay, you will need the time to become compliant. We would encourage you to go ahead and continue with your current project plans. The second reason is that it's not yet clear whether the delay will be partial or not. So it may turn out that some parts of MiFID are delayed and some parts of MiFID are not delayed, and exactly the parts that are not delayed you need to comply with. So we would encourage you to just keep on working towards your project as though this announcement didn't happen. Anyway, in the coming weeks, we will have more information as to whether there will be a delay or not, whether how long the delay will be, and whether the delay will be for the entire MiFID regulation or for parts of it. So for now, we have so little information that I don't think it's wise to change our actions based on it. Here are a few key dates regarding MiFID, and I'd like to draw your attention on a couple of those dates. The first one is Q2 2016, and this is the MiFID application date. This is the date when MiFID will be implemented as a law in the UK. And the second date is 3rd of January 2017, which at present is the date when MiFID takes effect. You see that's less than a year away, so we need to use our time wisely and be as efficient as possible. Here are the main key areas under MiFID. And I would like to explain something to you, and that's about the idea of our presentation. We're not going to go into the great technical detail of those areas because I'm sure you'll agree that in 45 minutes it's impossible to cover everything. Instead, we're going to provide an overview of what is changing and how to approach it, especially from project management perspective. So I'm going to say a few sentences to all of these areas. Just give a brief overview of which one of those. And I'm going to focus on 3 of them in particular, which we think are kind of the more relevant to the people and the firms we've been speaking to. So I'm going to talk about organizational requirements, conduct of business rules, and transaction reporting in more detail. But before that, I'd like to spend just a little bit of time to cover the remainder of the areas and just give you a bit of understanding about what they are about. So first one is commodity derivatives. And there are quite a few rules under commodity derivatives within MiFID II. And what we believe is the most important one is that there will be limits on the positions held in commodity derivatives. And that's going to be for all positions that are held not for hedging purposes. Even if you're a firm that is not operating in the financial services sector, if you have a position in commodity derivatives that is not for hedging purposes, you will have to comply with the MiFID rules. The next area is transparency, and indeed there are stronger rules regarding pre- and post-trade transparency. Obviously, this may have some impact on your IT systems, which Ian is going to talk about later on. Then we have high frequency trading, and there are about 5 different high level changes under high frequency trading. The reason for that, high frequency trading wasn't kind of looked at under MiFID I because simply it wasn't that popular. But since the introduction of MiFID I, high frequency trading, the activity has picked up a lot. So MiFID II now regulates those firms as well. I'm just going to mention the basic intuition behind the rules regarding high frequency trading, and that's that they'd like to ensure that the investors are protected properly from the activities of high frequency trading firms, and that these firms are not interfering with the integrity of the market. Market structure framework is the next area I'm going to talk about, and here for those of you who are familiar with MiFID I, you'll know that the multilateral trading facilities were introduced, and therefore trading equities and equity-like instruments. Now MiFID II is introducing the organized trading facility, which is the same as the multilateral trading facility, but only for trading everything else except for equity and equity-like instruments, so non-equity instruments. And finally, we have trade reporting. And I'll just give you an example of the new developments under trade reporting. So there will be a consolidated tape of trade reports available free of charge 15 minutes after it's been published. And that's going to cover equity and equity-like instruments, and it's envisaged to be available from 3rd of January 2017. About 2 years after that, the idea is to have the same kind of consolidated tape, but for non-equity instruments. And again, that's going to be available free of charge 15 minutes after it's been published. So you can see this is a vast amount of information that's going to, it's going to be to your disposal for free. So you can, you're free to analyze it and base your decisions on it. Now, let's look into some of the areas that I'd like to cover in a bit more detail. And the first one to start with is organizational requirements. The requirements under organizational requirements are basically the same or very similar to the principles of good corporate governance. And perhaps most of you are already compliant with those principles, but definitely now is a good time to review your current structures, for example, management, remuneration, and risk management as well, and just to see whether it's compliant with MiFID. So management bodies, the first one is about ensuring that the management of the organization has the sufficient knowledge, experience and expertise to be running the company. Some firms will also have to set up committees which ensure that the decisions in the firm are not influenced by one person or one group of people. A good way to ensure that actually is to have a sufficient number of non-executive directors on your board, and these non-executive directors need to be independent and also have relevant experience. So there is nothing new about that. As I say, it's all part of good corporate governance, but you need to look into your current arrangement and ensure they're compliant. The next area is remuneration, and again, there is nothing new there. We've all seen it before. All the requirements have been covered under the remuneration code and, for example, AIFMD. So in essence, the remuneration should be such that it avoids conflicts of interest, meaning that your employees put the needs of the clients first, um, and obviously they're not taking any excessive risks. It is really intuitive and common sense, but perhaps it's less easy to achieve that on practice, and this is why so many regulations are spending time to explain that. And finally, we have risk management. And here it's important to ensure that you have good procedures in place to manage risks that affect your organization, and especially the risks that affect your client. For example, managing the risk that you're selling the wrong product to your client. Again, now is a good time to review your risk management framework and ensure you have risk mitigation policies for all the risks that impact your company. The next area I'm going to look at is conduct of business rules. And it is quite comprehensive. It includes within itself quite a lot of different areas. And I'm going to start with inducements. Interesting thing to mention here is that under RDR, firms were allowed to keep legacy holdings which paid trail commission. However, under MiFID, firms will not be allowed to do so any longer. So if you do have such legacy holdings, you have to think about how to restructure and reinvest the client's funds into another investment that is not paying trail commission. In any case, this definitely means that there will be a potential loss of revenue for your organization because you will no longer get the trail commission. Another interesting fact is that now all research will have to be explicitly paid for. So it's a very common setup that investment firms will get a free research from brokers as long as they're paying for dealing commissions. This can no longer be the case, and now brokers need to charge explicitly for the research they're providing to firms. This obviously has implications to both the brokers and the investment firms, and especially when it comes to the brokers, it will have huge implications on their strategy going forward. And finally, you have to disclose all payments from third parties that you receive to your clients. First of all, you have to ensure that you have the right systems in place to report this to your clients, and second, you may need to think about how this will impact the relationship that you have with your clients. The next area I'm going to talk about is product governance. And here it's relevant to mention that MiFID is splitting the products into complex and non-complex. And there are very few products which are non-complex. These are equities, bonds, and some UCITS funds. Firms will not be able to send complex products on execution only or advisory basis. In order for firms to be able to sell those products, they'll need to run an appropriateness test. And obviously this change has implications on your systems, on communicating with your clients, and perhaps training your front office people. Another interesting fact regarding product governance is that now both product manufacturers and product distributors will share the responsibility for ensuring that the clients get the right kind of product for them. So, for example, those firms that manufacture products, they'll need to say upfront about the investor who is most likely to benefit from this product. So there will have to be an investor profile associated with each product. And then the product distributor will need to feed back information to the product manufacturer and explain exactly what type of clients have bought the product in reality. The next area is best execution, and we did have best execution under MiFID I, but now the rules have strengthened, and there is additional information that you need to disclose. For example, the top 5 trading venues. And another new requirement is that you have to disclose this information on best execution or your best execution policy. You have to disclose it to the clients and to the retail clients as well. So it may be challenging to write it in such a way that is understandable to the retail clients. And finally, we have client communication, there has been a huge increase in the requirement to collect client communication. So previously, or at the moment, it is 6 months, and going forward, it will be 7 years. And it doesn't only include, it's not only covering telephone calls, it also includes other information such as emails that you've exchanged with the clients, letters, minutes of meetings or other meeting notes, and so on. And the final area I'd like to cover in more detail is transaction reporting. We already had transaction reporting under MiFID I, but it was only for equity instruments. Now non-equity instruments are also included, and the amount, the pieces of information or the data points that you need to disclose has increased from 23 fields to 65 fields. I'll just give you some examples of the additional data fields that you need to include. So previously, when under client name, it was sufficient to include only the name of the firm. You didn't have any issues with identifying the underlying clients. But now you'll have to identify the underlying clients, and the way to do that is for non-individual clients, you'll need to supply a legal entity identifier, and for individual clients, you have to have a client identification number. Regarding the legal entity identifier, our conversations with different firms show that it's quite difficult to obtain this number. Some firms will even, some clients will even not have this number. So all the non-individual clients will have to have a legal entity identifier, which means that all trusts, charities, companies will have to have one of those numbers. And at the moment, very few of them have. This can prove to be challenging. Regarding individual clients, in order to identify them, you may need to disclose their name or date of birth, which already raises some data protection questions and issues. So you need to ensure that you're not breaching any data protection rules. Another example of information that you may need to disclose is the originator and executor of the trade. So usually these are two different people in most organizations. Usually someone in the front office, like an investment manager, will originate the trade or have the idea about the trade, and then a dealer would execute the trade. So your system will need to have the capability of capturing this information and then reporting it. And one final thing to mention about transaction reporting is that previously the regulator have said that under MiFID I, a lot of firms were over-reporting, meaning that they were reporting trades that they shouldn't have reported. And now the regulator have said that they will be less tolerant towards over-reporting, which means that you'll need to have the right systems in place to ensure that you're only reporting the trades or the transactions that you're supposed to. Now that's all from me. Thank you very much for listening. I'm going to pass over to my colleague Ian, who is going to talk about how to deal with MiFID from a practical point of view.
Thanks, Avaya. So as you can see, there's a lot of detail in this regulation and there's a lot of wide-ranging scope. So I think there's a big challenge for organisations to be able to put together a project that will cover everything, that can still be controlled centrally and can be managed effectively in whatever project framework your organisation prefers. So what I'm going to do, I'm going to just talk through some of the impacts that you're going to need to think about. I don't necessarily have the answers for a couple of reasons, because the specific ways you need to implement these changes are going to depend on your current organisation arrangements, both structurally and technologically. And secondly, and perhaps more disturbing, is the lack of clarity that's coming out from Europe on the detail of the regulations and the detail of the timescales. I don't know, I literally got an email just before this presentation started, which is a news report showing the head of ESMA, Stephen Major. ESMA is the European Standards Authority, and the head, Stephen Major, has had a quote saying, I don't know what the delay is going to be. It might be a year, it might be more than a year, it might be shorter than a year, it might be all of MiFID, it might be parts of MiFID. So when senior officials in Europe are coming out with those sort of quotes, I think it's a very, very fluid state of affairs in terms of this overall regulation. So what can you do? What you need to do is start doing your impact analysis. You've got the big picture of what the regulation is about. You can start looking at your organization, your arrangements, and work out what the impacts are going to be with what you know at the moment. And then once that impact analysis is completed, you're going to be in a much, much better position to be able to start planning for your change project to become compliant with MiFID II. So on the basis of that impact analysis, let's have a look at what those impacts might be. And again, it's structured broadly on the various points that Surveyor talked through. Again, I'd stress this is a very brief 45-minute webinar. We have not got the time to look at every last point of MiFID II. So we're looking at the impacts of some of the key points for financial services and for wealth management firms. So from an organizational point of view, what are the impacts? You've got three areas here on this slide. Management, looking at your, for example, your non-exec directors. Non-execs have got to have a maximum of 4 directorships. So if any of your NEDs have got more than 4, which is potentially very likely, you need to talk to them. Do you need them to resign some of theirs? Do they need to resign yours? Do you need to look at recruiting new non-execs? Not a trivial piece of work. Secondly, your senior staff have to have signed up that they understand and agree all of the responsibilities in terms of risk management, in terms of governance for the firm. Now, this will be a recurring theme, but I think most well-run firms should be able to tick those boxes very straightforwardly. It should be a no-brainer almost that your senior staff can fulfill those roles, but you need to be able to evidence that to the regulators and show that you've gone through the necessary rigor to confirm that your staff have got those responsibilities. The next level down from that is your committee structure. Are the proper committees in place? Investment committee, risk committee, etc. And do they have the remits? Do they have the approach? Is it all documented that they are fulfilling those functions correctly? Again, I'd very much hope that well-run firms do all of this, but you've got to demonstrate it and you've got to be able to evidence it. Remuneration policy, moving on. Again, hopefully your policy already meets the requirements of MiFID II, but you need to confirm that there aren't any conflict of interest. The policy is structured so that the needs of the firm and the needs of the individual are aligned. And lastly, risk management. There's a whole new load of rules on risk management in terms of recording data, in terms of analysing data. I think there's two levels here. First of all, you need to make sure your policies are in place and are correct and up to date. Secondly, and perhaps more challengingly, you need to make sure your IT systems and your procedures and processes can record, analyze and report on all the necessary data points that you're going to need to look at. And that covers things like best execution policy. It covers things like suitability information for clients, both on an overall level and on an individual trade level. And just to reiterate, it's not just having the policies and procedures in place, but can you source this data? Can you hold it centrally in your core systems? Can you report on that data? So a lot of analysis work there that's required. Looking a bit at the conduct of business rules, the products piece, there's this complex and non-complex definition that's been introduced by part of MiFID II or expanded as part of MiFID II. You need to look at the products that your firm either produces and distributes or resells on behalf of distributors, and we're talking about funds, investment vehicles here. And the ruling is basically that anything that isn't a straightforward equity or bond instrument or a UCITS certified fund is deemed as a complex product. So that covers things like private equity. It covers things like non-UCITS funds, for example, overseas that you might be invested in. And there are a lot of new rules around those non-complex funds, most notably that EXO investors, execution-only clients, cannot invest in those complex products unless you jump through a lot of hoops in terms of going through suitability for that individual product with the client and making them aware of various disclaimers. So there's another technological challenge there. First of all, can you record on your core systems whether or not products are complex or non-complex? And then for the complex products, can you ensure that the relevant procedures are followed by your front office and operational staff to be compliant with the regulations? Best execution, you need a best execution policy that you can demonstrate is being followed, and it needs to cover a lot more instruments than the current best execution policy. You also need to demonstrate to the regulators and to your clients that you are following that best execution policy. And the wording I've seen says that the policy has to be detailed and complex enough that it covers every aspect that it needs to and is sufficiently rigorous, but it also needs to be written in plain language that a retail investor can understand. And there's a couple of those are probably two conflicting requirements there, so drafting that policy is perhaps a challenge. The final bullet point on this slide, talking about client communication recording, I think there's two levels of challenges here. First of all, the simple telephone recording, the vast increase in data that is going to need to be retained to take you from 6 months of recorded history to 7 years. So there's already a big increase in storage that's going to be required. You may also need to look at your license arrangements with whatever telephone recording system you already have, because you may need to record more lines. That is because the requirement now is to make sure that any client communication that may at some point result in trading activity or a transaction is recorded. So that's telephone calls, it's emails, it's letters they may send in, it's minutes of meetings, anything along those lines. I would expect that most firms already record most of that information. However, some of it might be on spreadsheets, some of it might be on Outlook, some of it might be on document management systems, some of it might be on meeting notes that are put in a hard copy file. How do you record, how do you collate all of that information together so you can analyze it, you can recall it if necessary, and you can understand the implications on your trading policy with your clients? If you don't have a CRM system, I think that's possibly a very good starting point. Look at what a CRM, a client relationship management system, can provide in terms of pulling all of those various data points together and collating them, reporting them against individual clients. Okay, moving on to reporting. Two key aspects of reporting. First of all, we'll talk about client reporting. A lot more challenges here on what you have to tell your clients about. It's not just enough anymore to show them what their investments are and what they've done over the last 6 months. First of all, you need to report quarterly as a minimum. So potentially for some firms, you've got an increase in frequency there and an associated increase in costs. You've got additional information you need to put on that report. You need to show in detail your commissions and expenses that that have been undertaken in dealing with your clients' investments. You need to talk about, or you need to alert the client if their portfolio has dropped in value by 10% over the reporting period. Although at the moment that 10% figure or the detail of how that 10% figure is reached is very unclear. For example, how and when you take into account new money or money paid away from the portfolio. You also need to tell your clients what the top 5 trading venues are for their portfolio, and explain to them why you've chosen those trading venues. So there's a lot of additional information that needs to be shown in those reports. Can your systems deal with that currently? Do they need to be upgraded? Do they need to be improved or enhanced to provide that reporting information? Secondly, if you are currently, or if you are planning to allow clients to have access to their reports online, either supplementing paper reports or as a replacement for paper reports, then you need to be able to demonstrate that the client has read those reports online. Whether you do that automatically by showing that a client's visited a particular page, whether you do that by some sort of tick box or checkbox that a client has to complete. Again, not specified how you do that, but there's clearly a challenge there, I think, to record that additional level of information. Second part of this slide is talking about transaction reporting. Surveyor, I know, has gone through the detail or some of the detail of what's required in terms of the number of fields increasing significantly. And the question from my point of view is, how do you record that information? Again, you know, I'm repeating myself somewhat here, but it's worth hammering the point home. Your systems will probably not currently record all of the fields that they need to in terms of this new reporting. Do they have a field for an LEI? Probably not, because it's potentially a new concept. Do they have a field for the originator or the executor of the trade internally? No, I doubt it. You may need to have individual client identification and individual staff identification recorded on your system. So, and you also need to expand this to a much wider range of instruments than you're probably doing currently. So I think there's a number of challenges there from a purely technological and operational point of view, even before you start thinking about how you're going to deliver these transaction reports to the necessary regulators. So pulling some of those themes together, I think talking to your system providers is very important, even at this early stage, even when there are still uncertainties. I've spoken to a number of system providers, and there is a slightly disturbing lack of knowledge, I think, in what needs to be done in terms of changes, in terms of upgrades and enhancements to core systems. And as a wealth manager, as a financial services firm, you're slightly on the hook for those system providers being able to deliver. So you need to start talking to them and say, right, guys, what is actually happening here? Are you on the case with these changes that need to happen from a MiFID point of view? I'd add to that in-house resources. Whenever you do system change, you're looking at significant specification work, you're looking at testing, you're looking at enhancing or improving interfaces, improving reports, you're looking at training users, all of those high resource hungry activities that need to happen for system change. So again, something to think about in terms of planning and going forward. So that's just a little bit about the impact and what needs to be done. I could probably talk for another 45 minutes or another 45 hours about the detail. If you want more detail, you can look at things like the FCA website. There's a lot of good stuff on there. The trade bodies. I was talking to the Wealth Management Association before Christmas, who are doing a lot of good work in terms of feeding back to the regulator and lobbying on the detail. And I would stress you need to keep your ear to the ground in terms of the news that's coming out of Europe in terms of delays and revised timescales for the legislation. But notwithstanding all of that, I think it's essential to crack on now to start looking at the impact assessment, to start thinking about how you're going to successfully implement the changes, to engage all areas of the business. This is not just about compliance, this is about operations, it's about technology, it's very much about the front office. They need to start understanding what these changes are going to mean and what the potential impacts are going to be on their business areas. And I take that all the way up, in fact, to the board, the executive management, because there are potentially challenges and changes here to business models on a strategic level for things like the complex, non-complex product mix, for things like the inability to pay for research or to accept research as free research as part of the commission, as part of your broker arrangement. So those fundamental changes have potentially got impacts on firms' business models. So a little bit about change management. I think change management for something of this magnitude is essential. You can't just expect things to happen organically. You need to be in control of the process. So right from understanding the impact assessment, planning what change needs to happen, making sure that the right people are in place, making sure there's a proper program management, project management change structure and methodology in place so that you can understand your progress against a plan, so that you can track risks and issues, so that you can communicate to all stakeholders, and that might be senior management, it might be clients, it might be the regulators, it's probably all of those and more. You need to be able to communicate to them what changes are happening and give them confidence that you are on track with your MiFID project approach. So a little bit about the perhaps the timeline. I think the first one I've got there is appoint a sponsor. Perhaps not most people's initial point of view, but I think a proper project sponsor, and by that I mean a senior member of staff who is appropriately placed to make the necessary decisions, who has the gravitas and the experience to understand the impacts, who has the ear of perhaps the CEO or the COO to make them clear what changes need to happen and to push it through. Once you've got that, the impact assessment is key. Talked a little bit about that over the previous slides, but the impact assessment is all about making sure that you understand what's going to happen to your business with these new MiFID rules. You're then talking about looking at the strategy and putting a plan together, get your team members in place, make sure you've identified the individual projects or work streams that need to happen, and then look pushing those changes through. The first two are the key there, I think, at the moment, while there's still some level of uncertainty. So a sponsor, and then work out what that impact is going to be. This slide is just looking at some of the work streams. This may differ depending on your firm or your particular circumstances, but you're looking at business organisation in terms of processes, procedures, and the whole business model. On a strategic level, you're looking at compliance to really be the sort of subject matter experts in terms of what the regulation means. Risk management need to understand what the changes to the policies are, what additional data they're going to need to require. An IT work stream is probably key. There are a lot of changes that are going to be required to systems on a number of levels. Reporting, you could argue that's within IT, but I've split it out because I think the reporting changes are so fundamental and so important, because they are your window on the world, if you like, to your counterparties and your clients. I think it's important to cover that separately. HR need to look at things like staffing and remuneration policies. They need to look at committee structures. They need to look at experience, etc. And finally, communication. You need to communicate internally to everyone in the business who might be impacted. You also need to communicate externally to your clients, to the regulator, to the counterparties, to your counterparties, to make sure they understand what's happening and what's going on. Okay, a few conclusions there. I'm not going to cover all those boxes. I'd just say that the top one there, time is short. Time is uncertain at the moment, and if you don't start now, you do run the risk, I think, of being left behind as and when the timescales firm up. So I think starting now, or really pushing forward if you haven't started, if you have already started, is really key.